Mr. Justice Clifford dissenting. I concur that the judgment in this case should be arrested, but for reasons quite different from those given by the court. Page 92 U.S. 560 power is vested in Congress to enforce by appropriate legislation the prohibition contained in the 14th Amendment of the Constitution, and the 5th section of the Enforcement Act provides to the effect that persons who prevent, hinder, control, or intimidate, or who attempt to prevent, hinder, control, or intimidate any person to whom the right of suffrage is secured or guaranteed by that amendment from exercising such right by means of bribery or threats, of depriving such person of employment or occupation, or of ejecting such person from rented house, lands, or other property, or by threats of refusing to renew leases or contracts for labor, or by threats of violence to himself or family. Such person so offending shall be deemed guilty of a misdemeanor, and on conviction thereof shall be fined or imprisoned, or both, as there provided. 16 Stat. 141. Provision is also made by Sect. 6 of the same act that if 2 or more persons shall band or conspire together or go in disguise upon the public highway or upon the premises of another with intent to violate any provision of that act or to injure, oppress, threaten, or intimidate any citizen with intent to prevent or hinder his free exercise and enjoyment of any right or privilege granted, secured to him by the Constitution and laws of the United States, or because of his having exercised the same, such person shall be deemed guilty of felony, and on conviction thereof shall be fined or imprisoned, or both, and be further punished as therein provided. More than 100 persons were jointly indicted at the April term 1873 of the Circuit Court of the United States for the District of Louisiana, charged with offenses in violation of the provisions of the Enforcement Act. By the record, it appears that the indictment contained 32 counts, in 2 series of 16 counts each, that the first series were drawn under the 5th and 6th sections of the Act, and that the second series were drawn under 7th section of the same Act, and that the latter series charged that the prisoners are guilty of murder committed by them in the act of violating some of the provisions of the 2 preceding sections of that Act. 8 of the persons named in the indictment appeared on page 92 U.S. 561 the 10th of June, 1874, and went to trial under the plea of not guilty previously entered at the time of their arraignment. 3 of those who went to trial, twit, the 3 defendants named in the transcript, were found guilty by the jury on the first series of the counts of the indictment, and not guilty on the second series of the counts in the same indictment. Subsequently, the convicted defendants filed a motion for a trial, which motion being overruled, they filed a motion in arrest of judgment. Hearing was had upon that motion, and the opinions of the judges of the Circuit Court being opposed, the matter in difference was duly certified to this court, the question being whether the motion in arrest of judgment ought to be granted or denied. 2 only of the causes of arrest assigned in the motion will be considered in answering the question certified. 1, because the matters and things set forth and charged in the several counts in question do not constitute offenses against the laws of the United States and do not come within the purview, true intent, and meaning of the Enforcement Act. 2, because the several counts of the indictment in question are too vague, insufficient, and uncertain to afford the accused proper notice to plead and prepare their defense, and do not set forth any offense defined by the Enforcement Act. 4 other causes of arrest were assigned, but in the view taken of the case it will be sufficient to examine the 2 causes above set forth. Since the questions were certified into this court, the parties have been fully heard in respect to all the questions presented for decision in the transcript. Questions not pressed at the argument will not be considered, and inasmuch as the counsel in behalf of the United States confined their arguments entirely to the 13th, 14th, and 16th counts of the first series in the indictment, the answers may well be limited to these counts, the others being virtually abandoned. Mere introductory allegations will be omitted as unimportant for the reason that the questions to be answered relate to the allegations of the respective counts describing the offense. As described in the 13th, the charge is that the page 92 U.S. 562 defendants did, at the time and place mentioned, combine, conspire, and confederated together between and among themselves for and with the unlawful and felonious intent and purpose 1 Levi Nelson and 1 Alexander Tillman, each of whom being men, and there, a citizen of the United States of African descent, and a person of color, unlawfully and feloniously to injure, oppress, threaten, and intimidate with the unlawful and felonious intent, thereby the said persons of color respectively, then, and there to hinder and prevent in their respective and several free exercise and enjoyment of the rights, privileges, and immunities and protection granted and secured to them respectively as citizens of the United States and citizens of the state by reason of their race and color, and because that they, the said persons of color being then, and their citizens of the state and of the United States, or then, and their person, African descent in race, and persons of color, and not white citizens thereof, the same being, a right or privilege granted or secured to the said persons of color respectively in common with all other good citizens of the United States by the federal Constitution and the laws of Congress, matters of law conceded in the opinion of the court may be assumed to be correct without argument, and if so, then discussion is not necessary to show that every ingredient for which an offense is composed must be accurately and clearly alleged in the indictment, or the indictment will be bad and may be quashed on motion, or the judgment may be arrested before sentence or be reversed on a writ of error. United States v. Cook 17 Wall 174. Offenses created by statute as well as offenses at common law must be accurately and clearly described in an indictment, and if the offense cannot be so described without expanding the allegations beyond the mere words of the statute, then it is clear that the allegations of the indictment must be expanded to that extent, as it is universally true that no indictment is sufficient which does not accurately and clearly allege all the ingredients of which the offense composed so as to bring the accused within the true intent and meaning of the statute defining the offense. Authorities of great weight, besides those referred to by me in the dissenting opinion just read, page 92 U.S. 563, may be found in support of that proposition. 2 East P.C. 1124 Dord v. People 9 Barb 675 Ek v. State 23 Miss 525 Estate v. Eldridge 7 Eng 608. Every offense consists of certain acts done or omitted under certain circumstances, and in an indictment for the offense it is not sufficient to charge the accused generally with having committed the offense, but all the circumstances constituting the offense must be specially set forth. Arch, C.R. Lace, 15th ed. 43. Persons born unnaturalized in the United States and subject to the jurisdiction thereof are citizens thereof, and the 14th Amendment also provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Congress may doubtless prohibit any violation of that provision, and may provide that any person convicted of the same shall be guilty of an offense and be subject to such reasonable punishment as Congress may prescribe. Conspiracies of the kind described in the introductory clause of the 6th section of the Enforcement Act are explicitly forbidden by the subsequent clauses of the same section, and it may be that if the indictment was for a conspiracy at common law and was pending in a tribunal having jurisdiction of common law offenses, the indictment in its present form might be sufficient even though it contains no definite allegation whatever of any particular overt act committed by the defendants in pursuance of the alleged conspiracy. Decided cases may doubtless be found in which it is held that an indictment for a conspiracy at common law may be sustained where there is an unlawful agreement between two or more persons to do an unlawful act or to do a lawful act by unlawful means, and authorities may be referred to which support the proposition that the indictment, if the conspiracy is well pleaded, is sufficient even though we not allege that any overt act had been done in pursuance of the unlawful combination. Suffice it to say, however, that the authorities to that effect are opposed by another class of authorities equally respectable and even more numerous, which decide that the indictment is page 92 U. Thus 564 bad, unless it is alleged that some overt act was committed in pursuance of the intent and purpose of the alleged conspiracy, and in all the latter class of cases it is held that the overt act as well as the unlawful combination must be clearly and accurately alleged. 2 reasons of a conclusive nature, however, may be assigned, which show beyond all doubt that it is not necessary to enter into the inquiry which class of those decisions. Correct. 1. Because the common law is not a source of jurisdiction in the circuit courts, nor in any other federal court. Circuit courts have no common law jurisdiction of offenses of any grade or description, and it is equally clear that the appellate jurisdiction of the Supreme Court does not extend to any case or any question in a case not within the jurisdiction of the subordinate federal courts. State v. Wheeling Bridge Ompany 13 Howe 503. The United States v. Hudson et al. 7 Cranch 32. 2. Because it is conceded that the offense described in the indictment is an offense created and defined by an act of Congress. Indictments for offenses created and defined by statute must in all cases follow the words of the statute, and where there is no departure from that rule, the indictment is in general sufficient, except in cases where the statute is elliptical or where, by implication, other constituents or component parts of the offense is where the words of the statute defining the offense have a compound signification or are enlarged by what immediately precedes or follows the words describing the offense, and in the same connection. Cases of the kind do arise, as where, in the dissenting opinion in United States v. Reset al. Supra p. 92 U.S. 222, it was held that the words offer to pay a capitation tax were so expanded by a succeeding clause of the same sentence that the word offer necessarily included readiness to perform what was offered, the provision being that the offer should be equivalent to actual performance if the offer failed to be carried into execution by the wrongful act or omission of the party to whom the offer was made. Two offenses are in fact created and defined by the 6th section of the Enforcement Act, both of which consist of a page 92 U.S. 565 conspiracy with an intent to perpetrate a forbidden act. They are alike in respect to the conspiracy, but differ very widely in respect to the act embraced in the prohibition. 1. Persons two or more are forbidden to ban or conspire together or go in disguise upon the public highway or on the premises of another with intent to violate any provision of the Enforcement Act, which is an act of 23 sections. Much discussion. That clause is certainly unnecessary, as no one of the counts under consideration is founded on it or contains any allegations describing such an offense. Such a conspiracy with intent to injure, oppress, threaten, or intimidate any person is also forbidden by the succeeding clause of that section, if it be done with intent to prevent or hinder his free exercise and enjoyment of any right or privilege granted or secured to him by the Constitution of the United States, or because of having exercised the same. Sufficient appears in the 13th count to warrant the conclusion that the grand jury intended to charge the defendants with the second offense created and defined in the 6th section of the Enforcement Act. Indefinite and vague as the description of the offense there defined is, it is obvious that it is greatly more so as described in the allegations of the 13th count. By the act of Congress, the prohibition is extended to any right or privilege granted or secured by the Constitution or laws of Congress, leaving it to the pleader to specify the particular right or privilege which had been invaded in order to give the accusation that certainty which the rules of criminal pleading everywhere require in an indictment. But the pleader, in this case, overlooking any necessity for any such specification and making no attempt comply with the rules of criminal pleading in that regard, describes the supposed offense in terms much more vague and indefinite than those employed in the act of Congress. Instead of specifying the particular right or privilege which had been invaded, the pleader proceeds to allege that the defendants, with all the others named in the indictment, did combine, conspire, and confederate together with the unlawful intent and purpose the said persons of African descent in page 92. U.S. 566 persons of color then, and there to injure, oppress, threaten, and intimidate, and thereby then, and there to hinder and prevent them in the free exercise and enjoyment of the rights, privileges, and immunities and protection granted and secured to them as citizens of the United States and citizens of the state, without any other specification of the rights, privileges, immunities, and protection which had been violated or invaded, or which threatened, except what follows, to wit, the same being a right or privilege granted or secured in common with all other good citizens by the Constitution and laws of the United States. Vague and indefinite allegations of the kind are not sufficient to inform the accused in a criminal prosecution of the nature and cause of the accusation against him within the meaning of the 6th Amendment of the Constitution. Valuable rights and privileges, almost without number, are granted and secured to citizens by the Constitution and laws of Congress, none of which may be with impunity invaded in violation of the prohibition contained in that section. Congress intended by that provision to protect citizens in the enjoyment of all such rights and privileges, but in affording such protection in the mode there provided, Congress never intended to open the door to the invasion of the rule requiring certainty in criminal pleading, which for ages has been regarded as one of the great safeguards of the citizen against oppressive and groundless prosecutions. Judge Story says the indictment must charge the time and nature and circumstances of the offense with clearness and certainty, so that the party may have full notice of the charge and be able to make his defense with all reasonable knowledge and ability. 2 Story Const. Sect. 1785. Nothing need be added to show that the 14th count is founded upon the same clause in the 6th section of the Enforcement Act as the 13th count, which will supersede the necessity of any extended remarks to explain nature and character of the offense there created and define. Enough has already been remarked to show that that particular clause of the section was passed to protect citizens in the free exercise and enjoyment of every right or privilege granted, page 92 U.S. 567, or secured to them by the Constitution and laws of Congress, and to provide for the punishment of those who band or conspire together in the manner described to injure, oppress, or intimidate any citizen, to prevent or hinder him from the free exercise and enjoyment of all such rights or privileges, or because of his having exercised any such right or privilege so granted or secured. What is charged in the 14th count is that defendants did combine, conspire, and confederate the said citizens of African descent and persons of color to injure, oppress, threaten, and intimidate with intent the said citizens, thereby to prevent and hinder in the free exercise and enjoyment of the right and privilege to vote at any election to be thereafter had and held according to law by the people of the state or by the people of the parish, they, the defendants, well knowing that the said citizens were lawfully qualified, vote at any such election thereafter to be had and held. Confessedly, some of the defects existing in the preceding count are avoided in the count in question, as, for example, the description of the particular right or privilege of the said citizens which it was the intent of the defendants to invade is clearly alleged, but the difficulty in the count is that it does not allege for what purpose the election or elections were to be ordered, nor when or where the elections were to be had, held. All that is alleged upon the subject is that it was the intent of the defendants to prevent and hinder the said citizens of African descent and persons of color in the free exercise and enjoyment of the right and privilege to vote at any election thereafter to be had and held according to law by the people of the state or by the people of the parish, without any other allegation whatever as to the purpose of the election, or any allegation as to the time and place when and where election was to be had and held. Elections thereafter to be held must mean something different from pending elections, but whether the pleader means to charge that the intent and purpose of the alleged conspiracy extended only to the next succeeding elections to be held in the state or parish, or to all future elections to be held in the state or parish during the lifetime of the parties, may admit of page 92 U.S. 568 a serious question which cannot be easily solved by anything contained in the allegations of the count. Reasonable certainty, all will agree, is required in criminal pleading, and if so, it must be conceded. We think that the allegation in question fails to comply with that requirement. Accused persons, as matter of common justice, ought to have the charge against them set forth in such terms that they may readily understand the nature and character of the accusation, in order that they, when arraigned, may know what answer to make to it, and that they may not be embarrassed in conducting their defense. And the charge ought also to be laid in such terms that, if the party accused is put to trial, the verdict and judgment may be pleaded in bar of a accusation for the same offense. Tested by these considerations, it is quite clear that the 14th count is not sufficient to warrant the conviction and sentence of the accused. Defects and imperfections of the same kind as those pointed out in the 13th count also exist in the 16th count, and of a more decided character in the latter count than in the former, conclusive proof of which will appear by a brief examination of a few of the most material allegations of the charge against the defendants. Suffice it to say, without entering into details, that the introductory allegations of the count are in all respects the same as in the 13th and 14th counts. None of the introductory allegations alleges that any overt act was perpetrated in pursuance of the alleged conspiracy, but the jurors proceed to present that the unlawful and felonious intent and purpose of the defendants were to prevent and hinder the said citizens of African descent and persons of color by the means therein described in the free exercise and enjoyment of each, every, all, and singular the several rights and privileges granted and secured to them by Constitution and laws of the United States, in common with all other good citizens, without any attempt to describe or designate any particular right or privilege which it was the purpose and intent of the defendants to invade, abridge, or deny. Descriptive allegations in criminal pleading are required to be reasonably definite and certain, as a necessary safeguard, page 92 U.S. 569, to the accused against surprise, misconception, and error in conducting his defense, and in order that the judgment in the case may be a bar to a second accusation for the same charge. Considerations of the kind are entitled to respect, but it is obvious that, if such a description of the ingredient of an offense created and defined by an act of Congress is held to be sufficient, the indictment must become a snare to the accused. Scarcely possible that an allegation can be framed which would be less certain or more at variance with the universal rule that every ingredient of the offense must be clearly and accurately described so as to bring the defendant within the true intent and meaning of the provision defining the offense. Such a vague and indefinite description of a material ingredient of the offense is not a compliance with the rules of pleading in framing an indictment. On the contrary, Such an indictment is insufficient and must be held bad on demurrer or an arrest of judgment. Certain other causes for arresting the judgment are assigned in the record which deny the constitutionality of the enforcement act, but having come to the conclusion that the indictment is insufficient, it is not necessary to consider that question.